The First Amendment protects free speech, including expressive conduct, but does it shield someone burning the American flag in protest? In Texas v. Johnson, the United States Supreme Court answered that question. In 1984, Gregory Lee Johnson participated in a protest of the Republican National Convention. Outside the Dallas City Hall, Johnson doused an American flag with kerosene and set it on fire. As the flag burned, protesters chanted, quote, "America, the red, white, and blue, we spit on you," unquote. Johnson was charged with desecration of a venerated object under Texas law. The trial court convicted Johnson, fining him $2,000 and sentencing him to 1 year in prison. The Court of Appeals for the 5th District of Texas affirmed. However, the Texas Court of Criminal Appeals reversed, concluding that Johnson's punishment violated the First Amendment. The United States Supreme Court accepted the case to determine whether states could criminalize burning the American flag. The court concluded that flag burning is expressive conduct protected by the First Amendment. As a result, state laws criminalizing flag burning were content-based speech restrictions that didn't survive constitutional scrutiny. Writing for a 5-justice majority, Justice Brennan concluded that the First Amendment protected flag burning because it contained a sufficient level of communication. By burning the flag, Johnson intended to convey a particular message, and it was likely that anyone who witnessed his conduct would understand that message. For First Amendment purposes, the government has more leeway in regulating expressive conduct than it does in regulating written or spoken words. When speech and non-speech elements are combined in a single course of conduct, a sufficiently important governmental interest in regulating the non-speech element can justify an incidental limitation on First Amendment freedoms. To qualify for this more lenient standard, the state has to assert an interest unrelated to the suppression of expression. Texas asserted 2 possible interests to justify Johnson's punishment. First, flag burning caused breaches of the peace. Second, Texas wanted to preserve the flag as a symbol of national unity. The first interest wasn't implicated in Johnson's case. Texas admitted that no actual breach of the peace occurred. The second interest was directly related to Johnson's political message and therefore didn't qualify for the more lenient standard. Because the restriction on Johnson's speech was content-based, the court subjected Texas's asserted interest to the most exacting constitutional scrutiny. Under that scrutiny, the state's interest in preserving the flag as a symbol of national unity didn't justify Johnson's punishment. The court didn't object to Texas's goal, only its means. Preserving the flag as a symbol of national unity was a legitimate state interest that could support laws regulating how the flag may be displayed. But it couldn't justify criminal punishment for burning the flag. The ideal way to preserve the flag's special role in society was not by punishing those who express contrary views, but by attempting to persuade them with further dialogue. Therefore, the court affirmed the judgment of the Texas Court of Criminal Appeals, holding that the First Amendment barred criminal punishment for burning the American flag in protest. Justice Kennedy concurred, opining that while he found flag burning distasteful, the facts and applicable law compelled the majority's result. Chief Justice Rehnquist, joined by Justices White and O'Connor, dissented. Rehnquist argued that Johnson had many ways of making his point and that Texas law criminalized just one of them. Johnson remained free to express his viewpoint in a myriad of ways. For Rehnquist, flag burning was a form of fighting words, which is speech that inflicts direct injury or incites an immediate breach of the peace. Any expressive benefit derived from flag burning was clearly outweighed by the public interest in maintaining peace and order. Rehnquist also pointed out that 48 states and the federal government agreed with this reasoning, as they had statutes prohibiting flag burning on their books too. Justice Stevens also dissented, reasoning that Johnson wasn't prosecuted for his message, but for the method he used to convey it. Permitting flag burning tarnishes the flag's value. In contrast, criminalizing flag burning was only a trivial burden on free speech, particularly in light of the many alternative methods one has for communicating political ideas. Texas versus Johnson remains a source of deep disagreement. In 2006, Congress tried to amend the Constitution to prohibit flag burning and fell short by only 1 vote.